the legal field. Although technology can assist in decision making, there are limitations and even pitfalls in its over-dependence. Technology, it is stated, is a good servant but a bad master. It is proposed to have some discussion on the opportunities and challenges in the use of artificial intelligence in judicial dispensation. In the recent times, we have taken all-out measures for improvement of the working of the tribunal by filling up the vacant positions of members and the supporting staff. There has been a significant achievements in the field of development of infrastructure. In the last 2 years, we inaugurated our own buildings at Lucknow and a state-of-the-art building at New Delhi at the hands of the Honorable Law Minister. Presently, the construction work of the buildings at Kolkata and Ahmedabad is underway and is expected to be completed early next year. Consistent efforts are being made to identify land and premises at stations where the benches are housed in rented buildings. Recently, we had a breakthrough in resolving a long-standing dispute of a land at Guwahati with the active intervention of the Honorable Law Minister. Guwahati bench caters to as many as 7 northeastern states. With the policy of the central government to overall development of the Northeast, the importance of the Guwahati bench cannot be overstressed. We have also made significant strides in the integration of technology in the day-to-day working of the tribunal by providing facility of e-filing and virtual and hybrid hearings. In fact, the e-filing of the appeals by the revenue has been made compulsory from 30th of June 2023. Experience is that the assessees are also taking benefit of the said facility in a significant manner. I am happy to place on record that in the last 5 years, the pendency in the tribunal has come down from 87,500 to 44,500, that is less than 50%. The consistent hard work and efforts taken by the members of the tribunal has contributed to the reduction of the pendency with the active assistance of the advocates, chartered accountants, and the departmental representatives. I take this opportunity to request all the stakeholders for their continued support and cooperation in the future. I once again welcome the Honorable Governor of Maharashtra and the dignitaries on and off the dais and the participants for their presence. I hope and trust that the conference will go a long way in achieving its objective and there would be a significant takeaway at the conclusion of the conference. Thank you and Jai Hind.
Now I request Honorable President to felicitate the Honorable Governor with shawl and shriffle. And a token memento on behalf of all of us. We now invite you to witness a special audio-visual presentation to tribute to the enduring journey of the Income Tax Tribunal. This film is not merely a montage of images and the milestone, it is a reflection of ITAT's unwavering commitment to impartial, easy and speedy justice. It captures the history of salient dedication of the institution that stood as the beacon of fairness in India's tax jurisprudence. Now let us turn our attention to the screen where
time is often counted in years, but legacies, they're etched in moments of illumination. Across 84 revolutions of the earth, the moon has bloomed fully 1008 times, each radiating the essence of constancy, clarity, and completeness, just as justice must. In 1941, amidst a world at war and a nation under colonial yoke, a quiet revolution began, not on the streets, but in the sanctum of reason. The Income Tax Appellate Tribunal was born. Not with fanfare, but with foresight. A sanctuary where fact triumphed over force and truth over tyranny. Its creed? A trinity divine. Nishpaksh, Sulabh, Satvar Nyay. Impartiality, accessibility, swiftness. These are not mere words. They are the tribunal's solemn oath to the nation. From the bustling corridors of Mumbai to the silent hills of Guwahati, ITAT speaks in many tongues, yet always in one voice of justice. 30 cities, one constitutional conscience. Each full moon since 1941 has seen the tribunal scripting a saga of interpretive clarity, of fiscal balance, of jurisprudence shaped with intellectual precision. One of the richest tax archives in the democratic world. As the final fact-finding body in the tax appellate system, ITAT is neither ornamental nor optional. It is the judicial conscience of India's fiscal fairness. Behind every order lies a mind. Behind every mind, a mission. Members, registry, clerks, and council, the unnamed architects of this institution's quiet excellence. A symbol of institutional grace, its judgments form part of our constitutional inheritance. मदर ऑफ ट्रिब्यूनल्स के रूप में प्रतिष्ठित ये संस्थान देश की कर न्याय प्रणाली की एक मजबूत एवं निष्पक्ष आधारशिला रहा है. As the final fact-finding authority in the tax appellate hierarchy, the tribunal has played a pivotal role in ensuring that complex tax disputes are educated with intellectual rigor, institutional independence, and procedural fairness. As India marches on its journey to become Viksit Bharat by 2047, ITAT's role in delivering justice and time-bound dispute resolution within the direct tax ecosystem is more crucial than ever. Since its establishment in 1941, the ITAT has played an exemplary role in resolving direct tax disputes by delivering high-quality judgments, thereby making its motto of Nishpaksh Sulabh Satvar Nyay a reality. Honored by presidents, trusted by taxpayers, and upheld by every passing regime, the ITAT stands above the fray, beyond the fleeting. The tribunal is not frozen in time, it flows with it. From pen to pixel, from volume to virtual, ITAT rewrote the grammar of justice, digitally and decisively. In its 84th year, the torch is borne by retired Honorable Justice C.V. Bhadang, a jurist of depth, a leader of action, guiding with wisdom, reforming with resolve. And so, the tribunal gathers under a coastal sky, with sand beneath and stars above, to celebrate not just an anniversary, but an idea that justice, like the ocean, is deep, boundless, and ceaseless. Income Tax Appellate Tribunal since 1941, Nishpaksh Sulabh Satvar Nyay.
We now arrive at a moment of a quiet pride and enduring significance, the formal launch of the coffee table book commemorating 84 luminous years in the journey of the Income Tax Appellate Tribunal. Now I request the Hon'ble Dignitaries to unveil our coffee book table. This book is far from more than mere assemblage of images and text. It is a curated chronicle of our institutional soul, a tapestry that interweaves legacy, values, and the steady evolution of a tribunal that has profoundly shaped the contours of the tax jurisprudence in India. What renders this tribute truly exceptional is the vision and animated by our president, Mr. Bhadang, whose deep sense of history and refined aesthetics sensibly gave birth to this endeavor. Each page of this volume reflects not merely the milestone we have crossed, but the ethos with which we have traversed this journey silently, steadily, with unwavering rapport. Now we are all waiting for this moment where our chief guest, we want to invite him for this address. Before that, Shri C.P. Radhakrishnan, the Honorable Governor of Maharashtra, have assumed the office on 31st July 24, earlier served as Governor of Jharkhand and held additional charge of Governor of Telangana and Lieutenant Governor of Puducherry. Born in 1957 in Tirupur, Tamil Nadu, he holds a bachelor's degree in business administration. A lifelong Swayamsevak of the RSS, he began his public journey with Bharatiya Jansangh in 1974 and rose through the ranks of the BJP. He was elected twice to the Lok Sabha from Coimbatore, 98 and 99, and served on several key parliamentary committees including Textile, PSUs, Finance and Stock Exchange Scam Board, Probe. He was also part of the Indian delegation to the UN and Taiwan and many other countries. As state president of BJP Tamil Nadu from 2004 to 2007, he undertook 19,000-kilometer Rath Yatra and led several campaigns on national and social issues. He later served as a chairman of the Coir Board from 2016 to 20, during which India achieved the record high coir exports and was BJP's All India in charge for Kerala for 2020-22. Known for his grassroots connect, Sri Radhakrishnan has extremely toured Maharashtra since assuming office with a special focus on higher education and tribal welfare. A sports enthusiast and former college table tennis champion, he has traveled widely across over 25 countries. Sir, we are deeply privileged for your gracious presence here, and now request you to illuminate this gathering with your address.
I touch and salute the holy feet of Bharata Mata, the most powerful and the most merciful. Today we are celebrating, as it is mentioned, after 5 years, the conference of All India Income Tax Appellate Tribunal and the ITAT in Goa. On this day, the dignitaries who are sharing the dais with me, Justice Ashwin Damodar Bobeji, the judge of the Bombay High Court, Justice Retired Chandrakant V. Padang, Honorable President of the Income Tax Appellate Tribunal, and Dr. Anju Prati Ranaji, Secretary, Department of the Legal Affairs, and CA Sri Charanjit Singh Nanda, President, the Institute of Chartered Accountants of India, Sri R.K. Pandaji, Vice President, ITAT Pune Zone, distinguished members of the ITAT, senior officials of the Income Tax Department, members from the bar and various benches, and my dear brothers and sisters. It is a great privilege and a pleasure to be present among such an illustrious gathering on the occasion of the 84th anniversary of the Income Tax Appellate Tribunal and the inauguration of the All India Members Conference. To stand before an audience composed of some of the finest minds in tax adjudication and jurisprudence is both a responsibility and a rare honor. The Income Tax Appellate Tribunal, established in the year 1941, stands as one of the oldest and the most respected quasi-judicial institutions in our Mother Bharat. Its very existence predates the Constitution of India, and yet it is ethos and functioning. The tribunal has embodied the spirit of constitutional values: impartiality, reason, fairness, and justice. Over these 8 decades, the tribunal has evolved not merely in form, but in function, from a modest appellate body into an institution whose decisions influence not only tax jurisprudence, but broader questions of economic governance and the rule of law. The motto of the tribunal, Nispaksh, Sulabh, Sadva Nyay, or impartial, accessible, and swift justice, is not just a ceremonial ideal. It is a living commitment that informs every aspect of its conduct. The justice to be established, when the justice get established, when the justice get delivered. Yeah, justice is always one. So many people put their argument in their own way, but it is for the judge to deliver the justice. The 2 judgments and the 2 judges will always living in my conscience and memory. That is Singa and Kunga, both of them, in spite of the pressures on you, how you can deliver a real justice is a living example. And they have established over the mighty people that you are not mighty, but as long as you are against the law, then your mightiness will come down. That is what is established. And this is one I always very proud of an Indian judicial system, that once the justice decided, the judge decided, want to deliver the justice, it can be delivered and nobody can stop it. And that ITAT has distinguished itself by delivering justice that is not only legally sound, but also citizen-centric, bridging the complexities of tax law with the need for clarity, transparency, and timely resolution. No law can be made which is so easy to establish. You make any law, then arguments can put the law into little difficult decision making. But who can make it simple? It is the consciousness of the judge can make it very simple. Recently I had one argument as a governor. One officer has come. There were so many allegations against him. But he was promoted. I asked the officer who was promoted, why you didn't consider all these things before the promotion? Then the next question was, there was an allegation that he was jailed for 2 days. Why he was jailed? It looks like a very fabricated, that one accident took place. One bus was running against him in his village, and there was a quarrel. And in spite of that, he wanted to establish his side's right. He has been jailed because of some influence. Then the second allegation was he has taken the drinks. and he has come to the duty with alcoholic influence. Then I asked him whether alcohol test has been done. No. Everything looks like fabricated. I have never seen it. I was not a part of it. But when you hear both the arguments, it looks like some section was against that particular person. Then I immediately delivered my judgment. It all looks like fabricated, so you have to give the responsibility of the promotion from the date when he has been questioned. Then I asked the officers that he should be allowed to serve in his higher position and all the benefits should go to him. Why I am telling this? Anybody can make an allegation against any good person also. There are only two witnesses. One is the God's witness, which will never come. Only you can feel. And the other one is our consciousness. Our consciousness can understand the real spirit of the case. Circumstances may be against or may be fabricated. We have to go through the real reasoning behind that case, and we have to deliver our judgment based on the reality. This cannot be explained by any law. This cannot be drafted by any legal expert. Only people who are handling it, they only can deliver the real justice through their judgment. But that needs a lot of integrity inside. And today, India, where tax compliance is growing alongside economic ambition, institutions such as the ITAT serve as a dual role as interpreters of law and as instruments of trust. The confidence of the taxpayer in the fairness of the system is in many ways built upon the strength and the credibility of forums like this tribunal. After all, just tax system is not merely one that collects, it is one that listens and deliberates and decides with integrity. That is very important, and this is the job of our ITAT. This commemorative conference is far more than a ritual observance. It is a moment of reflection and rededication. That is the very purpose of these type of conferences. Our enthusiasm had to get renewed. Our aspiration for establishing the justice, our aspiration for establishing the real good norms, all are getting renewed and redefined in our hearts. It invites us to look back at the milestones achieved, but also to look forward with the resolve and the imagination towards the challenges of tomorrow. As it is mentioned in the welcome speech, it has get reduced to a greater extent. But still, it shows that we have to go a long way. That we have to see the justice has to be delivered in the right time. Otherwise, there is no use of delivering the right thing also. So we have to speed up the things, how we have to act. I think this conference can discuss about that. What are the obstacles, where it is getting stuck, how we can speed up the judgments. And that spirit will really do a lot for the administration and also for the citizens. The ITAT's response to these emerging realities has been inspiring. Its embrace of digital reforms, including e-filing, virtual hearings, and paperless procedures, It is not just about efficiency, it is about democratizing justice by reducing pendency, eliminating procedural delays, and increasing access. The tribunal has become a model for how tradition and technology can coexist in service of to the citizens. As Governor of Maharashtra and Chancellor of its state universities, I would like to highlight a critical area that needs our urgent attention: the need to align legal education with the realities of modern day adjudication, including the specialized work of institutions like ITAT. Legal curricula in many of our universities remain outdated. But now it is gearing up as usual. Any reform will take its own time, but we have to speed it up. There cannot be two arguments against it. There is a growing need to incorporate focused training in tax law, financial regulations, forensic accounting, artificial intelligence in legal research, and global economic frameworks. We must equip our future lawyers and judges with not only knowledge of the law, but also the skills to interpret its application in a digital, borderless economy. I urge universities, legal educators, and regulators to collaborate with institutions like ITAT in shaping practical, case-driven, and technology-enabled legal educations. Internships, research fellowships, and judicial clinics should become an integral part of law courses, particularly in areas like tax law, commercial arbitration, and dispute resolutions. Our judiciary will only be as strong as the intellectual foundation we lay through our universities. As India marches towards the vision of Viksit Bharat, a Viksit Bharat or a developed economy cannot be called as a developed economy unless it is an inclusive development. It takes care of every section of the society. And the importance of the legal institutions, particularly those engaged in economic and fiscal adjudication, cannot be overstated. A nation inspiring for growth and prosperity must ensure that its revenue system is not only efficient in administration, but just in adjudication also. The ITAT's role in safeguarding this balance makes it not just a judicial body, but a silent partner in the nation's progress. The role of the ITAT is crucial not just in resolving tax disputes, but in upholding the faith of the taxpayers in the rule of law and fairness of our fiscal administration. Its reputation as the Mother Tribunal is well deserved, as it has set benchmarks for other appellate bodies across the country. The release of the coffee table book titled ITAT at 84, a chronicle of sustainability, is a testament to this legacy. It is more than a record of proceedings. It is a living archive of institutional wisdom, documenting not just judgments and members, but ideals, transitions, and transformative moments. It is a mirror to the past and a window to the future. I commend and congratulate the members of the tribunal, past and present, as well as the judicial officers and the departmental representatives, the members of the bar and the support staff who uphold the tribunal's high standards of adjudication. Often, the work of such institutions proceeds quietly without fanfare or public spotlight, but its impact is felt deeply in the fairness of taxation, in the assurance of due process, and in the very credibility of governance. May this conference spark thoughtful discussion, encourage bold reforms, and reaffirm the shared commitment to excellence and equality in tax adjudication. May the conference serve as the celebration of 8 decades gone and come up with a blueprint for the decades to come. That should be the spirit of this conference, and I am sure that spirit will be upheld by this conference. I thank you once again for this opportunity to join you in honoring this prestigious institution, and I extend my best wishes for the success of the conference and for the continued ascent of the Income Tax Appellate Tribunal in the service of our nation. This is the only resort for the taxpayer where he can put his case with real faith. And I wish you all every success in your endeavor. And Kup Kup Dhanabad, Jai Hind, Jai Bharat, Jai Goa, Jai Maharashtra.
Now I request Mr. Panda, Vice President Pune Zone, for his brief vote of thanks.
Honorable Governor of Maharashtra, Honorable Sri C.P. Radhakrishnan, His Lordship Justice Ashwin Damodar Bhobe, Honorable Judge Bombay High Court, Dr. Anjurathi Rana, Honorable Secretary, Department of Legal Affairs, Sri Justice Retired Chandrakant V. Badang, Honorable President, Income Tax Appellate Tribunal, my colleague Vice Presidents and members, distinguished guests, ladies and gentlemen. A very good morning to all. It is indeed an honor and great privilege to propose the vote of thanks at the inaugural session of All India Members Conference of the Income Tax Appellate Tribunal, which is celebrating its 84th year. I, on my behalf and on behalf of the Income Tax Appellate Tribunal, express my sincere gratitude to Honorable Governor of Maharashtra, Honorable Sri C.P. Radhakrishnan, who, despite his busy schedule, was kind enough to accept our invitation at a very short notice to be the chief guest of the inaugural session of the All India Members Conference 2025 and releasing profitable book on ITAT. Sir, we are really honored for your gracious presence and inspiring speech, which will be cherished in our memories for a long time to come. I also take this opportunity to express my sincere thanks and gratitude to His Lordship, Honorable Justice Ashwin Damodar Bhobe, Honorable Judge Bombay High Court, Dr. Anjurathi Rana, Honorable Secretary, Department of Legal Affairs, for accepting our invitation to be the guests of honor of All India Members Conference by taking out time from their busy schedule. We are really thankful to both of you, sir, for your gracious presence on this occasion. I thank Honorable Justice Retired Chandrakant V. Badang, President, Income Tax Appellate Tribunal, for organizing this All India Members Conference. It is because of your vision and interest, sir, that this conference could happen after a gap of about 4.5 years. I, on my behalf and on behalf of the entire Income Tax Appellate Tribunal, express my sincere thanks and gratitude to all the distinguished guests, officers of the Income Tax Department, officers of the Ministry of Law and Justice, Department of Legal Affairs, office bearers and members of various bar associations across the country, members of the press and electronic media for being present here and making this conference lively. Finally, I thank the officers and staff of the registry for their active cooperation in organizing this conference. Jai Hind.
Ladies and gentlemen, now we all stand up for national anthem.
सिंध गुजरात मराठा द्राविड जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We'll take a 10 minutes break and reassemble for the second part of the inaugural session. तक मैं स्टेज पे हूँ, करना मैडम को हटाइए मत।
इसको हटा दीजिए ना। बीपी बीपी यहाँ बैठी है ना। ये सर का है, ये हो गया ना, इसको हटाओ, ये हो गया। हाँ अच्छा, ये अभी मैं अजय वधवानी है, अभी मैं
ये तो यूज्ड ग्लास लग रहा है, तो हटाना है। मुझे स्टेपलर की अच्छा मैडम
उल्टा होना चाहिए था ना।
तो ये सब के लिए है, तो निकलवा के दूसरा रखना है। बोलूँ ये ग्लास और बॉटल यहाँ दे सकता है। No, ma'am. No, no, I'll just.
सर जितने भी डायस बैठे हैं उनके सबके लिए लेदर बैग्स है ना?
हाँ, उनके लिए।
एलएस और हाई कोर्ट जज सबके लिए बैग है ना? सबके लिए
मैम 125 बैग हैं, 100 ही मेंबर हैं।
25 बैग डेलीगेट्स के, जो भी स्पीकर्स हैं सबके लिए है।
मैम अब ये इसका काम तो खत्म हो गया। इसकी स्पीच मैं अपने हिसाब से कर लूँगा। देखिए ना what happened ना, ये लीजिएगा मैम। May I request everyone to take the seats. It's time to start our inaugural session 2 now. I request all the gentlemen outside. Now we'll commence our inaugural session 2. Now I'll request the dignitaries on the dais to come on the dais, please. Mr. Justice Ashwin Damodar Bhobe, Honorable Judge, Bombay High Court. Sir, you are welcome, sir. Our President, sir, Mr. Charanjot Singh Nadda. Dr. Anju Rathi Rana, Honorable Secretary. Honorable Mr. Justice Ashwin Damodar Bhobe, Dr. Anju Rathi Rana, Honorable Secretary DLA, Justice C.V. Bhadang, President ITAT, Mr. Sakji De, Vice President Mumbai Zone, and Charanjit Singh Nanda, President Institute of Chartered Accountant of India. Friends, as the gentle rains of Goan monsoon kiss the coastline, palms sway in welcome, we find ourselves gathered in this coastal haven, not merely to mark a passage of time, but to honor a living institution that has for 84 years stood as a sentinel of justice in India's tax landscape, the Income Tax Appellate Tribunal. To borrow from T.S. Eliot, time past and time future are both perhaps present in the time present. Indeed, we are suspended between a storied legacy and a luminous horizon. Since its inception in 1941, the ITAT has matured into a bastion of judicial independence, embodying the constitutional ideals of Nispaksh, Sulabh, Satvar, Nyay. Spanning 84 years, or poetically 1008 full moons, the tribunal has evolved not just in structure, but in spirit. In Indian philosophy, 1008 symbolizes wholeness, cosmic rhythm, and spiritual progression. In the same way, ITAT's journey through these lunar cycles has mirrored a steady revolution from its nascent beginnings to a confidence judicial forum. Each full moon in this celestial odyssey bears the silent testimony to the tribunal's unwavering commitment to truth and resolute pursuit of fairness. This inaugural session is more than a ceremonial. It is celebratory, a reaffirmation of our institutional ethos and tribute to those who have shaped it. We are profoundly honored by the presence of dignitaries who are present on the dais and other distinguished dignitaries whose guidance has enriched the nation's legal and fiscal infrastructure. Our annual conferences are just not mere a celebration. They are crucibles of thought and dialogue, Over the next 2 days, we shall engage with some of the finest minds, jurists, scholars, and practitioners as we explore evolving tax jurisprudence, both global and domestic. A defining focus in this conference will be the deliberation on the proposed New Income Tax Bill 2025, a legislative milestone with the potential to redefine our fiscal ecosystem. In understanding its contours, we do more than interpret law. We help shape the future of tax education in India. In this endeavor, IIT reaffirms its commitment to the national's vision of Viksit Bharat, an India that is not just economically advanced, but institutionally robust and judicially mature. For Viksit Bharat is not only a product of economic intent, but of legal clarity, fiscal accountability, and institutional excellence. The ITAT, as the sentinel of tax justice, remains committed to advancing this national mission. With that spirit and learning and legacy, I welcome you all to this gathering of minds and memories. Now I request our Honorable President to felicitate Justice Ashwin Damodar Bhobe, Honorable Judge of Bombay High Court. Now I request Honorable Vice President Shri Mahavir Singh to come on the stage and to felicitate our Law Secretary, Anju Rathi Rana. Now I request Vice President Mumbai Zone Shri Sakhjit Dey to felicitate Shri Charanjit Singh Nanda. First, we'll call upon Shri Charanjot Singh Nanda, President ICAI, for his address. But before that, it's my honor to introduce him. He's a dedicated professional chartered accountant. He is the 73rd President of Institute of Chartered Accountant of India for the year 25-26. With over 3 decades of service to the profession, C.A. Nanda has been a driving force within ICAI, holding several key positions at the regional, national, and international levels. His leadership is marked by vision, commitment, and a deep sense of responsibility towards the profession and society. As a president, he leads major institutional initiatives, regulatory collaborations, and international outreach, shaping ICAI's role in India and abroad. Respected for his humility, clarity, and tireless mentorship, he continues to be an inspiration for the professionals across generations. Please join me in warmly welcoming C.A. Charanjot Singh, and I invite him to give his address in this inaugural session.
A very good morning, ladies and gentlemen. Honorable Mr. Justice Ashwin Bhobe Sahab, Honorable Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Honorable Justice Chandrakant V. Bharang Sahab, President ITAT, Honorable Shri Saktijit De Sahab, Vice President ITAT, Mumbai Zone. Ladies and gentlemen, honorable members of the Income Tax Tribunal, respected dignitaries, esteemed colleagues and friends, I am truly honored to address today morning to this very enlightened gathering. It is truly a momentous moment when I'm able to speak to and express my views to the most elite class of people who drive justice in India. I want to very candidly put you that today's conference is focused on knowledge upgradation and capacity building. It is fitting to recall the timeless truth: justice delayed is justice denied. This principle lies at the heart of our collective mission to deliver impartial, swift, and expert adjudication in the field of direct taxation. The Institute of Chartered Accountants of India and the Income Tax Appellate Tribunal share a common purpose to ensure that tax laws are interpreted fairly and implemented effectively, safeguarding the integrity of the taxation system and protecting the rights of the taxpayers. You're all aware that ITAT has an unblemished career of over 84 years. I take this opportunity to congratulate you all on celebrating 84 years of ITAT, mother of all institutes. A great long life working to serve the members. Continuity very importantly. And I'm reminded of a couplet which says, अपने हौसलों को खबर करते रहो, अपने हौसलों को खबर करते रहो, जिंदगी मंजिल नहीं सफर है चलते रहो. We all have to move to create value, and ITAT over the years has done this. I like to say something about our institute also. Ladies and gentlemen, the Institute of Chartered Accountants of India was set up an Act of Parliament way back on 1st July 1949, when the most important document to the democracy, the Constitution, was not adopted. You are all aware that Constitution to this great country was promulgated on 26 January 1950. The pertinent question that arises is, what prompted the Constituent Assembly to set up an Institute of Chartered Accountants of India when its own democratic setup was not in place? The answer is very candid, very simple, very forthcoming. They were looking for a disciplined band of soldiers to steer this country out of confusion and put it on the path of perpetual progress and advancement. And there we are, chartered accountants, the financial soldiers of motherland India. Ladies and gentlemen, we had a humble beginning with 1,800 members, and today we stand tall as the largest accounting body of the world, with over 5 lakh chartered accountants and 11 lakh students. The entire world now looks up to the leadership of Indian professionals for all initiatives they intend to undertake. And I'm proudly saying this on this dais, that being an Indian is the greatest virtue I could ever have held. Ladies and gentlemen, moving ahead, I would like to take you to a very important thing. You're all aware that the economic growth that is demanding expertise. You're all aware that the real GDP, India clocked 7.4% growth in quarter four financial year 25, with full year growth estimated at 6.5%, marking the strongest quarter four performance amid 4 years moderation. Ladies and gentlemen, this economy is now becoming a leader worldwide. I can give an example. I joined the council way back in 2004. When I used to travel overseas, I could clearly see that we were viewed as second-rank citizens. And today the tables have turned. Today the entire world views us on a different perspective. We are treated as leaders. We are treated as people who would give solutions to their problems. I give an example. I was in London, India House, where Sardar Patel, Mahatma Gandhi, Nehruji used to go. The Indian Embassy's house there. I met the ICAI president there, institute which was set in 1880, Mr. Michael Beckus. And when he met, he said that, Mr. Nanda, we need help of India to ensure that trade is properly executed in UK. See how tables have turned. कहते ना देते ना थे जो जवाब उनके सलाम आने लगे. देते ना थे जो जवाब उनके सलाम आने लगे. वक्त बदला तो मेरे नीम के पेड़ पर आम आने लगे. My dear friends, times have changed and we have to gear ourselves to take a note of that. Going ahead, ICAI is a catalyst for financial excellence. We at ICAI do a lot of things. We'll do a lot of work on income tax, direct tax. We have a direct tax committee. And when the income tax bill 2025, when it was tabled, we were the first called, sir. On 6th March, the honorable bench called us at the parliament to make our presentations how we could take forward the initiations and amendments which they feel in Income Tax Act. I'll give you 3 very important things which we propounded. The first important thing, the act was too big. We wanted them to be pruned to close to 450, 443 sections. The second important thing, interpretation issues on which various legal issues arise. We said that the language has to be kept very simple so that people are able to effectively interpret and use them for their professional values. And third and final thing, we have to be user-friendly. If we are tax-friendly, taxpayer-friendly, things move right in the right esteem, people are encouraged to work and give their best. So ladies and gentlemen, other than, well, we get engaged with policymakers. We have an MOU with C&AG office. We had MOUs with close to 10 international bodies and 90 universities to ensure that we are able to effectively create an infrastructure, an environment where young students stand up to be brand ambassadors of this great country. Ladies and gentlemen, moving ahead, I take you to a very important thing which I would like to say, sir. It may be worth considering whether the current eligibility criteria requiring practicing chartered accountants to have 25 years of experience for a 4-year tenure could be revisited. Since morning, so many people have represented, sir. You are here, sir. If something goes from you, Law Ministry has to consider it in a positive manner, sir. Let it be equitable with the advocates' 10 years. And 4-year terms, sir, more respectfully, I'd like to submit. I know it is sub judice before the Supreme Court, but that also is a matter of concern. People who want to come into practice, people who have an unblemished career, who want to contribute really, after 4 years, they can't go back and practice. So that is something that is ultimately putting them. Madam, Anju is also there, madam. It is for your kind consideration. Also, if you work in that proposition, we'll move ahead in great area. Both the Institute of Chartered Accountants of India and ITAT play pivotal roles in direct tax ecosystem, serving complementary functions that together uphold the integrity, fairness, and efficiency of India's tax administration. We have expertise in direct taxation. We are committed to justice and fairness, which both of them work incessantly to create that. Statutory foundations, I told we have set up an Act of Parliament 1941. You are a force to reckon with. Internationally also, people always speak about ITAT with great regard and honor. And we have a nationwide reach. Sir, we have 179 branches and our presence is in 85 countries with chapters and representative offices. And by the end of the year, we are hopeful that we'll cross the century mark, and internationally also, we will have the greatest issue. To conclude, the key areas of collaboration between ICAI and ITAT. Sir, first, knowledge sharing and training. Sir, we have got good resources. Wherever you want, a training has to be conducted. Knowledge sharing sessions have to be conducted. I'll be more than happy to take care of that and ensure that best of the faculty come. We are doing that for C&AG officers also. We can do for any person, any officer where you deem fit, sir. Second is digital enablement. You'll be happy to know 81% of international IT initiatives emerge from India. Leave aside artificial intelligence, blockchains. We have become world leaders now on Internet of Things, data analytics, and more importantly, cyber security audits and information system audits. Sir, any help you required in ITAT, I say as the 73rd president of the institute, we stand committed to the fact that we have to serve the country. APJ Abdul Kalam Sahab very rightly said, Indian chartered accountants are partners in nation building. Yes. And as times are changing, I feel that it will be Indian chartered accountants are partners in global building now, sir. So whenever anything you require, sir, we are at your beck and call. We'll be very happy to serve this great organization. Infrastructure support, sir. ICAI offers its branch premises and facilities for ITAT's circuit and camp hearings, especially in remote locations. Wherever you need, sir, we are there. Research and publications. We are doing so many research. I told you I visited India House. Mr. Vikram Dura Swami, the consulate head, we are doing a research with them on how UK trade could benefit from Indian chartered accountants. In fact, yesterday I was in Shillong with the Honorable Finance Minister, Madam Nirmala Sitharaman, and Mr. Sangma, the Chief Minister of Meghalaya. They said, I'll take 1 minute and tell you. He said with a very heavy heart, very painfully, he said, I went to a place and I saw a lot of flowers, a wedding, crores of rupees, a huge wedding. He said, from where do you get the flowers? They said, we get it from Thailand. He said, you get it from Thailand? And Northeast has so many flowers. The man said something which touched my heart. He said, if you order from Thailand, you get at the right time. If you order at Northeast, it comes after 5 days. So then and there we decided that we'll have a research on how to ensure that equitable delivery of goods be undertaken. I told them yesterday and we're publishing a research paper on that. So any area where you want us to do any research, any publication, we'll be happy to do that, sir. Quality representation and compliance, very important. Policy dialogue and thought leadership, which has been our forte. We shall be very happy to assist you all in any area where you want our indulgence. To end with, sir, progress is not person-centric. Progress is not something that delivers when you think from your mind. You deliver when you think from your heart. The most important thing is that at times we try to mix our heart and head. There's a very celebrated couplet in Urdu which says, "Ruhon mein bhi daag aa jate hain, jab dilon mein dimag aa jate hain." My last parting words to you, let us all work together with our heart to make India the one of the most developed countries of the world. It is something which has to happen, but let us all work to make it happen early. Let us be leaders of worldwide initiatives so that we can establish the supremacy which we had years earlier. I want to thank you, sir, for inviting me for this conference. We all have to work together to make India a great country. Thank you. Thank you so much, sir.
Now, we'll request our Honorable Secretary DLA, Dr. Anju Rathi Rana, and before that, we all know that she is well known to all of us for her approachability and ever-willing readiness to extend support to the tribunal. Thank you, ma'am, for coming and gracing this inaugural function. Dr. Anju Rathi Rana, an officer of the Indian Legal Service with over 3 decades of distinguished service, currently serves as the Law Secretary of the Government of India, heading the Department of Legal Affairs in the Ministry of Law and Justice. With a strong academic background, LLB, LLM, PhD in law, and a career spanning public prosecution, legal advisory, and high-level policy making, she held several key positions, including Additional Secretary, Legal Advisor to major union ministries. A gold medalist and a Lok Sabha Research Fellow, she has represented India at multiple international legal forums, including Shanghai Cooperation Organization. As India's first woman law secretary, Dr. Rana brings to the role a rare blend of legal acumen, administrative depth, and quiet leadership, making a milestone in the evolution of India's legal governance. Ma'am, we request you to please give this inaugural address.
First of all, thank you so much for inviting me. Respected Honorable Mr. Justice Ashwin Damodar Bhoveji, Judge, Bombay High Court. Retired Justice Shri C.V. Bhadang, President ITAT, Shri C.S. Nanda, President ICAI, Shri Shaktijit Dey, Vice President ITAT Mumbai Zone, honorable members of ITAT, members of the bar, officers from the revenue, distinguished guests, ladies and gentlemen. A very good morning to all of you. It gives me great pleasure to be here this morning at this inaugural session of the Income Tax Appellate Tribunal All India Member Conference 2025, one that marks the 84th anniversary of the Income Tax Appellate Tribunal and brings together some of the finest minds in tax law, policy, and adjudication. The ITAT stands as a symbol of institutional endurance and the intellectual integrity. Ladies and gentlemen, for over 8 decades, it has discharged its duties with remarkable independence, discipline, and discretion. Established on 25th of January 1941 under Section 5A of the Income Tax Act 1922, the ITAT is the oldest statutory tribunal in the country, now governed under Chapter 20B of the Income Tax Act 1961 and reflected in Sections 361 to 364 of the proposed Income Tax Bill 2025. From the outset, it was envisioned as a body independent of executive influence, a forum that would offer taxpayers as impartial, efficient, and expert adjudication. It has remained true to that vision. In a judicial landscape often challenged by pendency and complexity, the ITAT stands for its discipline, subject matter expertise, and procedural clarity. As one of India's earliest tribunals, it has shown that specialized forums, when backed by autonomy, domain knowledge, and well-reasoned orders, cannot only deliver justice, but do so with consistency and confidence. It is in many ways a living example of how tribunalized justice can work and work well. Even as the tax landscape around us has transformed dramatically with the rise of digital economies, cross-border structures, and evolving compliance ecosystem, the ITAT has remained a steady and trusted forum for fair adjudication. It is often referred to as the Mother Tribunal, having inspired the design of many other quasi judicial bodies that followed. This is not just a celebration of an institution's legacy, it is a reaffirmation of its continuing relevance. The tribunal today boasts nearly 100 members with a sanctioned strength of 129, a long journey from its early days with 4 members on 5-year contracts. Its alumni include several eminent jurists who went on to serve as judges of high courts and even the Supreme Court. Decisions of the ITAT, particularly on international taxation, have not only shaped domestic jurisprudence, but have also found resonance in foreign courts. That in itself speaks volumes about ITAT. As we begin this 2-day exchange of ideas, allow me to share 3 themes that I believe merit special attention in our times. First, the future of tax law lies in its adaptability with disruptive business models, borderless transactions, and emerging technologies. Our legal and adjudicatory framework must be prepared to revolve, not just to regulate, but to interpret wisely. The complexities of beneficial ownership, treaty interpretation, transfer pricing, GAAR, and multilateral instruments demand constant capacity building and sharper legal analysis. Secondly, adjudication must go hand in hand with accessibility. Procedural clarity, reasoned orders, and timely resolution are not just internal metrics of performance, they directly shape public trust. In this regard, the ITAT's record of clarity, consistency, and balance offers an enduring model. Third, we must embrace technology, not as a cosmetic upgrade, but as a structural necessity. E-filing, paperless documentation, real-time case tracking, and virtual hearings are no longer optional. Institutions like ITAT must lead this transition without compromising the sanctity of process. Tax, as we know, is more than a physical tool. It is a reflection of citizen-state relationship. At its core, tax justice is economic justice. It shapes the balance between compliance and fairness, between certainty and discretion, and because it affects every citizen and every enterprise, it must be delivered with proportion and principle. Tribunals like ITAT do more than resolve disputes. They signal that rule of law governs even the most technical of domains. As the Income Tax Bill 2025 seeks to simplify and modernize our tax code, your role becomes even more critical. One of the sessions during this conference will dive into the features of the new bill. I hope the deliberations not only clarify its intent, but help shape how it is implemented and interpreted in the years ahead. Another session will revisit the so-called basic concepts of income tax, concepts that, as Einstein once remarked, can often be the hardest to truly understand. In fact, I would like to share Alfred E. Rumen Riley put it, I quote, "Today it will take more brains and effort to make out the income tax form than it does to make the income." These discussions, I am sure, will be anything but basic. We just heard Mr. Nanda about the 4 years of the tenure. So I'll take up the matter with the higher-ups when I reach Delhi. And we used to call these members our Agniveers. The road ahead is not without its challenges. The globalization of tax policy, growing taxpayer awareness, and the demands of a fast-evolving economy will test all of us, lawmakers, administrators, and adjudicators alike. But I have no doubt that the ITAT will rise to meet the moment as it always has. As India moves towards the vision of Viksit Bharat 2047, the institutions like ITAT will not just interpret tax laws, they will help shape India's economic and moral architecture. So ladies and gentlemen, your judgments will be read not only by appellate courts, but by history as reflections of how we balance fairness, reason, and reform. Let me once again congratulate the President, ITAT, and Vice Presidents of the ITAT, and all the members of the organizing team for curating this important conference for the dialogue, reflection, and foresight. I look forward to the discussions ahead and wish this conference every success. Thank you. Jai Hind, Jai Bharat.
Thank you so much, ma'am. Now I'll request our chief guest of this session, Justice Ashwin Damodar Bhobe, Judge, Bombay High Court. He is truly a son of Goa. He was born in Goa on 14th February 1975. Justice Bhope completed his schooling at St. Brito's High School, Mapusa, and went to earn a BCom degree from Dhyan Prasak Mandal College. He pursued his legal education at VM Sagalkar College of Law, Panjim, graduating in 1998. He was enrolled as an advocate in 2001 with his seniority recognized from 1998 and practiced in the state of Goa, handling civil and criminal appellate work, constitutional matters and service law. Justice Bhope was elevated as an additional judge of the Bombay High Court on 25th October 2024. May I request to just give a brief address to all of us.
Good morning. Honorable Justice Badang, Honorable Ms. Rati, Honorable Mr. Chandrajot Singh Nanda, Mr. Satyajit Dey, the Honorable Vice Presidents of the Tribunal, Honorable Members of the ITAT, Honorable Members from ICAI, AI, members of the bar, members from the revenue or revenue officers, the press, a very welcome to you in Goa. As they have said, I am the son of the soil. Welcome to Goa. First of all, thank you, sir, for inviting me, but give me the privilege of welcoming you all to Goa. Goa is one of the smallest state, but known as gem on the western coast. So apart from this conference, if you get some time, please try to visit some parts of Goa. Goa will not disappoint you as far as its beauty, and you will be able to see 451 years of Portuguese rule, and that culture still prevails in Goa. I know that the conference is yet to start and there was a little delay, so I will not take much time. As a member of the bar, which I was not much long, I was told not to repeat the arguments, and even all these members will say, so I will not repeat what has been said by all these people, all the erudite speakers before me. But I would just like to say some parts. 84 years for ITAT is itself an achievement. 63 benches in 10 zones, 30 cities. And the achievement, because we always think as a High Court that we have a lot of pendency, we have to try to reduce. I was just told from 97, in the year 1997, there was about 3 lakh pending cases before the ITAT. And today, it has been reduced to almost less than 50,000. This itself requires a big salute to you all, sir. What an achievement by the members of the ITAT. Really, it's great. Justice Badang, one of the best judges of the Honorable High Court, and now ITAT. If I may use the word, or I may coin a phrase to say for Justice Badang is 24/7 judge. Apart from work, I don't think Justice Badang can do something else other than that. This must be the achievement of all the other members of the tribunal, the vice president, but I did not have the occasion. I had the occasion for 4 years to appear before Justice Badang. In that context, I'm saying he is really 24/7 judge. Everybody has spoken today that the tribunal is doing well. The tribunal has achieved so much by its hardworking members, its president, vice president. There is a contribution also from the members of the bar for this institution to come up to reduce its pendency. So we require some round of applause to the member of bar also. Mr. Charanjit Singh Nanda gave a reference to his institute, ICAI, the scope, the magnitude it is. Sir, your profession is really one of the, it is as equal or maybe more than our legal profession. So a round of applause to you also. Today we have had a lot of good word of wisdom from the Honorable Governor today. Even Justice Badang also had shared some of his views about the tribunal. And from all the other, Madam Rati was kind enough and she has assured you all that she would take up the issue as raised by Mr. Nanda. Please do that, madam, because it's also an issue which requires to be. So without any further ado, it is really an honor and a pleasure to be before you all addressing such erudite members, luminaries. Thank you for having me over here, and all the best for your conference. And again, I will repeat that please permit Goa to be a good host and just take some time to see the best places in Goa. Panjim does provide some good places. Thank you very much.
Thank you, sir, for such an impromptu speech, because we just requested 2 minutes before, if you can address. Thank you so much, sir. Now I request Shri Sakhji De, Vice President Mumbai Zone, to give a very brief vote of thanks.
So as instructed by Brother Sukla, I will be very brief. Respected dignitaries on and off the dais, ladies and gentlemen, I stand before this esteemed gathering to propose the formal vote of thanks for the inaugural session of All India Members Conference of the Income Tax Appellate Tribunal. I begin by expressing our deep gratitude to Honorable Justice Aswin Damodar Bhobe, Judge Bombay High Court, for sparing his valuable time to be with us today despite his demanding judicial schedule. Justice Bhobe is widely respected for his incisive judgments and clarity of thought, which have contributed significantly to the development of law. I thank Ms. Anju Rathi Rana, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Government of India, for her esteemed presence this morning. She has played a pivotal role in steering key legal reforms and strengthening institutional frameworks within the justice delivery system. My sincere thanks to Sri Charanjot Singh Nanda, President of the Institute of Chartered Accountants of India, for joining us today. He is known for his dynamic leadership and his unwavering commitment to the professional excellence and ethical standards of CA Fraternity. Ladies and gentlemen, it is often said that what starts well ends well. With the gracious presence of and inspiring words of all our dignitaries in this inaugural session, we are confident that this conference will be of immense benefit to all our members and stakeholders. And in this context, I will quote the words of Mr. Charanjot Singh Nanda, in times to come, नीम के पेड़ में जरूर आम आएंगे. Before concluding, I may also remind you that our first technical session on the subject, emerging issues in international taxation, would begin shortly. So I request your presence. Thank you. Thank you all.
Thank you. We'll just reconvene in within 5 minutes to start our first technical session.
वही कर रहे हैं. ये लो. क्या? मैं अन्नपूर्णा अन्नपूर्णा अन्नपूर्णा
we calling everybody on the stage? Nobody's listening. In beginning our first technical session. Please, the comfort break is over. Okay. I would request our esteemed speaker for the first technical session, Mr. Mukesh Bhutani, to please come on the dais. Thank you, sir. I would request Honorable Vice President, Bangalore Zone, Mr. Prashant Maharshi to be present on the dais, and Mr. Ajay Wadwaji, the President of the ITAT Bar, Delhi. Thank you very much. Time to put on our thinking caps and begin doing what we are here for in Goa, the technical sessions. As we are all aware, the first technical session is about emerging issues in international taxation. On the side, I had a discussion with the eminent speaker here today, Mr. Mukesh Bhutani, and what I gathered was that I'd better leave the nitty-gritties of the subject to him. A very learned and a distinguished person in this field of emerging issues of international taxation, though there is one aspect which I had put across to him and which he said he'll speak about from the dais, as to how does and how soon does it affect us as tax judges? How soon would cases relating to the amendments in international tax laws are going to affect us? I'm sure he's going to touch upon that. Plus, I would also request him to touch upon how the changing international scenario with, every country adopting an approach where they're just looking at themselves. It's no longer, it does not appear to be a global, outlook on things. Every country is just looking at their own interest. How effective will all these amendments be in the future? I would begin by requesting Honorable Vice President, Bangalore Zone, to welcome Mr. Mukesh Bhutani ji with a bouquet.
I'm sorry, it's a traditional shawl. I would request the Honorable Vice President to welcome Mr. Ajay Wadhwa with a memento, the coffee book table, coffee table book, whatever it is, and a shawl, of course. Thank you. Mr. Wadhwa, you'll get your chance to speak.
No. We must see what is in this. Please open it. Transparency.
It's the coffee book, coffee
This is all
table.
I'm good at. International tax, I don't understand the IT.
Oh, that's lovely.
Lovely. Lovely.
Mr. Bhutani ji expressed to me that 45 minutes is too short a time to cover all the important aspects of, the emerging issues in international taxation. But be that so, we have our limitations. And I said that from this dais, I would express his request to have a full-day seminar on this topic anytime in the future. I would now request the Honorable Vice President to begin with his introductory speech about Mr. Mukesh Bhutani and the subject.
Thank you, Madam Gupta. Subhashaya Galu. Mr. Mukesh Bhutani, the learned speaker today, is known by his books, which are available in almost all the libraries of ITAT, and every professional who practices the international taxation and transfer pricing. At some point of time, his books are referred to by us for writing our orders too. The introduction of Mr. Mukesh Bhutani is like this. An eminent practitioner by Chambers and Partners Asia Pacific 2025. The second laurel, litigation star by Benchmark Litigation Asia Pacific 2025. The third one, leading individual by Legal 500 Asia Pacific 2025. India's legal icon by India Business Law Journal 2025. And recommended by Asia Law Profiles 2025. Mr. Mukesh started his own practice earlier, and then he was leading the practice of Arthur Andersen at that particular time, and then became the international partners also in that firm. He has already set up two legal firms. One of them was in news for the remarkable profits that he has earned. And second one he is continuing with, and perhaps it is one of the leading legal firms on international taxation and transfer pricing. We welcome you, sir, here. Mr. Ajay Wadhwa, not unknown to anybody here, a prolific speaker, an articulate professional, and a very, very witty-minded arguing counsel. We welcome Mr. Ajay Wadhwa, who is president of ITAT Bar Association, Delhi, for how many years now, sir?
We'll have to ask my secretary. I think about,
So-
I think that's a better way of putting it. And, you know, now it's just been said that 75 is the year of retirement now for all professionals and, you know, even Mr. Modi. So another 13 years to go.
So hope it is applicable to you, sir. We welcome you both, sir. Now looking at the today's subject, it's a recent trend in international taxation. Mr. Bhutani will take us through that particular journey. The decision of Honorable Supreme Court in case of national essay had sent ripples across the globe, and perhaps the tax fraternity was not ready to accept that judgment. Mr. Mukesh is also associated with that particular issue for a fairly long time. He will take us to the nuances of that particular judgment and how it would be applicable. The simplest word in the English vocabulary is ease, that reached to the Honorable Supreme Court for its interpretation, and perhaps the tax fraternity is not happy with that. So he will deal with that. The second issue is the multilateral instruments. That is an instrument for entering into the double taxation treaty with many of the partners at one go, which would be very relevant for interpretation of double taxation avoidance treaties soon. Mr. Mukesh would take us through how it would be applicable, when it would be applicable, in which countries transaction we must see with the double taxation avoidance agreement, those multilateral instruments. Whether that will require a notification or not, a fresh notification or not, is also an issue which is debated across the country. Third is the word beneficial ownership, the concept which is not new in the domestic tax law, but now the same word, same phrase, same characteristics in international tax perspective is looked at by the various courts. Italian court has taken a view on that, where they have stated that tax residency certificate is not enough. The beneficial ownership, TRC, vis-a-vis the treaty entitlement of the SSC is now for a toss. The two decisions of the various one high court, in case of Blackstone and Global Tiger are stayed by the Honorable Supreme Court. In one of the cases, the decision is reserved. Another one is pending for, it's concluded, the arguments have been concluded. Soon we will know whether the Blackstone is merely a stone or the tiger will be tamed or roar in the jungle. Let us see. We request Mr. Mukesh Bhutani to discuss this issue, which is very relevant because before the tribunal, these issues come every day, twice. So, floor is yours, Mukesh.
Thank you very much for the introduction, Honorable VP Prashant Maharishi, Ajay, my friend, Honorable President of the Tribunal, Justice Badang, Vice Presidents, members, Fraternity, bar members, ladies and gentlemen. When I was asked for speaking on this topic, I was in double mind whether in 45 minutes you can do justice or not. And I had suggested to Mr. Amit Shukla, who had so kindly invited me. By the way, congratulations for a great start to a conference. I could see how well he is performing the role of an MC. That I wanted to pick up 2-3 themes and what would those three themes be in 45 minutes to just give a capsule of what are really the emerging international tax issues. Can I start first? Yeah. So what I made sure was that I pick up these three themes. One is the Nestle judgment. I think Nestle judgment is done and dusted, so we are here. It's a law. I'm not going to talk about what the law is. Everyone knows that. But I wanted to focus a little bit about, now that we have Nestle as a law, what does it mean for us, for the taxpayers, and for the administrations, and particularly for the tribunals who've given maximum judgments in areas of interpretation of double tax treaty. Then I wanted to focus a little bit about the multilateral instrument, the new standard of treaty interpretation. It's not that we have given a go-by to a multilateral, to a bilateral treaty, which is what we interpret, but now the bilateral treaty has to be interpreted with a multilateral treaty. And I just want to talk a little bit about the framework of the policy, how the discussion evolved, because this is really not the first instance of a multilateral tax treaty. There have been many, many examples of multilateral tax treaties beyond what is traditionally called a bilateral treaty. Bear in mind, when I'm making this statement, we shouldn't forget the first principle that we actually interpret only a bilateral treaty. But how do you now interpret it with a multilateral framework is something that I wanted to talk about and bring a little bit of Indian context, because we have not just rich jurisprudence, but we have the Constitution and we have the Income Tax Act, wherein Section 90 or the equivalent of Section 90, even in the 1922 Act, was very much prevalent. And then last but not the least, I wanted to talk about beneficial ownership and principal purpose test. This is really the new area of dispute that, in my view, is likely to arise. I wanted to trace the history of beneficial ownership to the 1977 first model convention of the OECD treaty framework and bring you to where we stand presently. Sir, as a moderator, please stop me if I'm exceeding my time limit. I know we are running short of time. Let me first talk about the Nestle judgment and what it means. So Nestle had three principles. I'm just quoting those three principles. We all know those three principles. The first one is the first principle, which says that a notification is mandatory given the framework of Section 9. There's a very important principle that the Supreme Court spoke about, this principle of equal treatment. And when it articulated this principle, which is there in the citation for everyone to read, and I'm not going to read that, it bore in mind the equal treatment that should be accorded to a tax treaty, the equal treatment that two nations should accord to each other. Now, it also took out the concept of Section 90, importance of notification. So the equal treatment theory is nothing but an extension of the main ratio that you need a notification to interpret the treaty. And then, as Mr. Maharishi correctly pointed out, the shortest word in English was interpreted. Now, interestingly, if you go back into the history of Nestle, it had two sets of appeals. Both the sets of appeals were arising out of a Delhi High Court judgment. One dispute, whether you need a notification to trigger in an MFN, is actually a 15-year-old dispute. And this is what my association started with when the Steria case came in. Do you actually need a notification to give benefit under MFN? The Delhi High Court said, no, you don't need it. It said it 15 years back. After that, there are 17 judgments of the tribunal, as I am told, which followed the Delhi High Court judgment. Some of the tribunals actually improved the Delhi High Court judgment in Steria's case and said why you don't need a notification. Not only that, the tax administration went ahead and actually granted refunds. I'm aware of taxpayers who actually filed a return and got the refunds because they sought for a most favored nation treatment. Now, that principle has got shaken up because of the Nestle judgment. So we don't know, even the tax administration is at loss. What should they do? Should they write back and ask them to return the money back, which they, out of their own, refunded to them? Now, the word "is" was really the subject matter of debate before the Supreme Court. It's just that because the 15-year-old Delhi High Court judgment in Steria's case was also heard along with this issue, then the Supreme Court was forced to mix up both the issues, and I would say even confuse both the issues. What was the dispute in the case of "is"? Whether the word present in the treaty "is a member of the OECD" should be read as "is a member of the OECD at the time of the convention." The word "at the time of the convention" was something that was being read at. The Delhi High Court said, no, you cannot read it at the time of convention. "Is a member of the OECD" means is a member of the OECD, full stop. So the most favored nation clause is present in treaties with Switzerland, France, and Netherlands. All the three treaties confer two benefits: withholding tax benefit under all the three treaties, and restricting the scope under one treaty, which is the French treaty. So the French treaty's definition of fees for technical services is restricted. This was the issue. And what were these three classes of taxpayers asking for? Or what did the Delhi High Court say for these three classes of taxpayers? That if these three countries are claiming the benefit, and these three countries happen to be in a situation where another country has got added to the OECD membership list, Slovenia, Lithuania, and Colombia, then the benefit that applies to these treaties will apply to your treaty as well. And that's why the use of the word "is" came up for debate. Now, actually, if you look at the treaties, or if you look at the framework of most favored nation, there are three kinds of words that have been used in the treaty. One is an automatic application, where it clearly says that then the benefit will be available. If it's a member of the OECD, then it'll apply. So that's a more dynamics. So if more countries get added to the OECD list, then, and if those countries have better treatment for withholding tax or scope, then that will automatically apply. It's present in India-France treaty, it's present in Netherlands treaty. Then there is conditional MFN benefit. India actually has treaties with conditional MFN benefit. So if you look at India-Finland or India-Saudi Arabia treaty, it says you need a formal notification. And then there is a hybrid variety. The hybrid variety is present in Switzerland, where it says that when it comes to rate of withholding tax, it is automatic, but when it comes for scope, you need to notify. So let's assume that India and Switzerland decide that the restricted definition of fees for technical services should apply to India-Switzerland treaty. It cannot apply automatically. The competent authorities have to get together for discussion. So these are the three kinds of MFN benefit that are there under the treaty. Now, in the Nestle case, the Supreme Court said that withholding tax for India-France, India-Netherlands, India-Switzerland will not apply automatically, and it will require a notification. Now, what did the Supreme Court miss in this judgment? It missed the fact that the words cannot be read into it. And why do I say that? When India signed a treaty with Netherlands in 1988, Netherlands had a treaty with Australia of 1976. And in that treaty between Netherlands and Australia, there was actually an MFN benefit. But that MFN benefit clearly said that it will apply only to those members of the OECD who were there at the time of the signature of India-Netherlands treaty, which means it was frozen in time. In 1976, when Netherlands and Australia entered into a treaty, it says only to the members of the OECD. It was static, it was not dynamic. So this is what, in my view, the Supreme Court missed at. Now, interestingly, if you read the India-Netherlands Treaty, there is also an MFN benefit, for those of you who are aware, on restriction on head office expenses. And it says that the restriction on head office expenses, which is under Article 7, will be frozen at the date of the signature, which means that India, Netherlands decided that as at the date of signing of the treaty, it will be frozen. In other words, in the same treaty, you have an MFN benefit that's dynamic, let's say for withholding tax on dividend, and in the same treaty, you have an MFN benefit which is not dynamic. This is something which, in my view, the Supreme Court missed out on. Now, when you enter into a treaty, the treaty also reflects the economic positioning of the country. Imagine India entering a treaty into 1988. Why do you give a MFN benefit? You give a MFN benefit because you really are expecting that this country means a lot from an economic cross-border investment perspective. So there was a conscious choice that India took to give this MFN benefit. Interestingly, when we went through the Registrar of Company records of the Dutch equivalent of Registrar of Companies, we realized that many Indian companies were claiming the MFN benefit. So when they were remitting dividends from Netherlands to India, they were actually paying only 5% withholding tax. So this dichotomy then takes us to the next slide, which is what is the jurisprudence that India has, and India has really rich jurisprudence on international law, not just on tax. In fact, all the cases that I have quoted here, which are all Supreme Court cases, only one is tax, which is the Ram Jethmalani case. Actually, I don't even consider the Ram Jethmalani case as tax, because in this case, there was a public interest litigation where the Supreme Court was just trying to decide one issue, that stolen data of the bank, whether the stolen data of the bank can be made public, or will India violate exchange of information clause with its treaty partners. And in this public interest litigation, the Supreme Court went ahead and set up an SIT to look into the offshore accounts. But what the Supreme Court said is the importance of the Vienna Convention on Law of Treaties, why treaties should be respected, and why the good faith principle should be followed. All the other judgments that I have quoted, none of them are tax judgments. The Agricas decision is a very interesting decision. Actually, it was given by none other than the Chief Justice who retired, Justice Sanjeev Khanna, in 2021, wherein he was dealing with a vexed issue of a circular issued by Ministry of Commerce, which was causing friction with India's commitment under GATT. And the question was, how do you really now reconcile a circular issued under a foreign trade policy with a GATT commitment that India has? To which the three-judge bench, and I quoted three-judge bench highlighting it because this case was specifically discussed in the Nestle judgment on para 27, but not dealt with in the judgment. The three-judge bench unequivocally said domestic law cannot be invoked to justify disregard of a treaty commitment. So what was happening was that a circular issued by Ministry of Commerce under the free trade policy was causing friction with what was a benefit coming to the importer under the GATT law, and the Supreme Court negated that. I'm not going to discuss all the other judgments. Vishaka, we know, Vishaka led into the POSH Act, harassment against women. Maganbai Ishurbai is a very interesting decision, which was a border dispute on the state of Kutch in Gujarat when India and Pakistan partitioned. And the then Chief Justice, Justice Hidayatullah, when he looked at the international law, he said, interpretation has to be in conformity with international obligation, and that must prevail. Godra Electricity is another judgment rendered in the context of Electricity Act, But it took me some effort to read the judgment of ICJ in Kuldeep Jadhav's case. We all know in Kuldeep Jadhav's case, India was fighting with Pakistan in the international court. And I actually was forced to read this judgment because when we were preparing for this case, Mr. Salve said, don't miss on this judgment. And my first impression was, how is Kuldeep Jadhav case even concerned with the Nestle case? But there is a very important principle in Kuldeep Jadhav's case, which was in the context of Article 36 of the Vienna Convention, which gives you consular access in those situations. Pakistan was taking a view that consular access can be denied because it's a charge of espionage against Kuldeep Jadhav, to which the ICJ negated that by saying that the customary international law will govern. And the customary international law here was Article 36 of the Vienna Convention, and that Pakistan cannot take shelter of domestic law and it cannot override to what is an acknowledged commitment. Jolly Varghese case is another example where Article 51 was emphasized upon, but I just thought I will throw in these cases because I expected that the court could have debated the Nestle judgment in the context of what is court's laid down principle, particularly on the Agricast decision, which is quoted in para number 27. Now, what does this mean for us if we have to live with the Nestle judgment? One, all these articles of the Vienna Convention are relevant for treaty interpretation. The Supreme Court dealt only with one article, 31(3)(b), and I'll come to 31(3)(b) because there is wide mention in para 87 onwards, and the conclusion is based on 31(3)(b). Most people ask me, does Nestle mean end of justice? And I said no. When you interpret a treaty, you need to now look at the Vienna Convention much more closely than you looked at it. You cannot just look at Article 31. You cannot just follow the good faith principle. You need to now look at it in a wholesome manner, but look at it carefully because 31(3)(b), an important element of interpretation under Vienna Convention, has been dealt with by the Supreme Court. We may not like the judgment, but the judgment is there, and that's the law of the land. But there are other important elements of the Vienna Convention. 31(1), the plain meaning rule. If something is very evident from a reading, why do you need to go to an aid of interpretation? It's fundamental and it's core to any interpretation in India. And similarly, 31(1) is the plain interpretation rule under the Vienna Convention, but it adds some very interesting nuances. It says the plain interpretation rule has to be in accordance with the ordinary meaning given to the terms of the treaty in the context and in the light of its object and purpose. There are 6 distinct elements in the plain interpretation rule of Vienna Convention, and this is, in my view, the fundamental rule. 31(2), the contextual interpretation rule. The contextual interpretation rule is very important. It's self-explanatory. I'm not going to read it, but I'm going to emphasize in the contextual interpretation rule on the preamble and the annexures. Third, subsequent practice treaty interpretation. This is what the Supreme Court talked about and came to the conclusion only on this rule. It says, there shall be taken into account, together with the context, any subsequent practice in the application of the treaty which establishes the agreement of the party. What the Supreme Court did not do, the agreement of the parties. It need not be a unilateral, one-way, one-country practice of a convention. Convention is established in a treaty when there is bilaterally followed. So the question that arises for consideration is that if Indian companies who were declaring dividends from Netherlands and India was accepting those dividends, is that a convention? Or is the convention one isolated event, a 1986 circular issued in the context of India-Canada Treaty, where India went ahead and notified justified a application of the most favored nation treatment? That question comes up for consideration. So the Supreme Court dealt with it in para number 74 and abruptly concluded in para number 87, and relying on 31(3)(b, concluded the need for notification. Finally, can internal law be an excuse to deny a treaty benefit? The fundamental principle is no. But the reality of the life today is it can. So let's take a case that under our general anti-avoidance, domestic law prescribes for overriding the treaty. But in case of abusive situations, in situations that demand the invocation, simply having an internal law to override a treaty is prohibited under Article 27. Now, some of my reflections, which I've already concluded, but 31(3)(b, reliance of the Supreme Court on one isolated circular that India issued. For people who have time on this one isolated circular, I happen to be one of the authors of this circular in 1986. This was issued in the context of India-Canada Treaty when ONGC had imported some Canadian helicopters in India, and those Canadian helicopters were being denied some treaty benefit or MFN arising out of a treaty that India subsequently signed with Sweden. So it was an India-Canada treaty which had an MFN clause looking out for a benefit. Treaty benefit, MFN benefit was denied pursuant to India signing a favorable treaty with Sweden, and that led the then celebrated IRS officer who became the Chief Election Commissioner, Mr. T.S. Krishnamurthy, call me into his room and say, "Son, sit down, this requires a CBDT circular." That was one isolated instance of India issuing a circular. So I think that post-Nestle, some other policy developments occurred, because suddenly we realized that all the benefit that is given to treaty partners, whether it is MFN on withholding tax, MFN on reduced scope of tax, MFN on restricted definition of fees for technical services arising out of a technical explanation in the India-US treaty. This technical explanation now being carried to other treaties, because no treaty has technical explanation. Only India-US treaty has technical explanation on the term called make available. There are 37 judgments of the tribunal on make available, all in favor of the taxpayer. Today, if I look at the relevance of the notification, that should not be available to the taxpayers. So, post-Nestle, there is a challenge. This challenge can, in my view, be addressed only with a change in law. What we are seeing is a bit of a repair work that is being carried out to address what could potentially be an awkward situation with some of our treaty partners. Let's take a case of Spain. India-Spain treaty has a most favored nation clause, but it doesn't have a notification. It shouldn't apply. But we decided that after 25 years, we'll issue the notification because the Supreme Court judgment came in. My view is that some of these aspects need to be looked into, and only it's the future of the policy that will speak out. But it is a challenge of sorts now for us to deal with what is the law of the land. Let me now move on to the multilateral instrument and interpretation in Indian context. Sorry, the slide is a little crowded, but hopefully when you have a look at the slide, you'll be able to read it. But really, there are too many words in this slide. The point I wanted to make is one simple thing. Ma'am, you mentioned about BEPS when we were talking. So BEPS has 14 standards. There is action point 6. Action point 6 gave birth to the multilateral instrument, action point 6 gave birth to the principal purpose test, and the principal purpose test is enshrined in the multilateral instrument as what is called a mandatory standard. Sir, I promised you I'll make it simple, but I will try and cover that in some of these slides to very briefly explain. The multilateral instrument has many standards. two of the standards are minimum standard, and one standard is the prevention of treaty abuse. And this standard articulates what is called the principal purpose test. I will look at the principal purpose test and explain very briefly in the Indian context. But very briefly, this multilateral instrument had a signing ceremony. India is a party to it. India attended the signing ceremony and was amongst the first 50 nations that signed it. The multilateral instrument came into force. This is a multilateral instrument, and how it will get incorporated in the double tax treaty is something that I'm going to explain. But it was in force from July 1, 2018. As of today, there are 105 jurisdictions which are party to the multilateral instrument, including India. Now, what does a multilateral instrument suggest? First of all, there are two fundamental rules of multilateral instrument. Signing of a multilateral instrument doesn't mean anything. There has to be an instrument of ratification that permits the multilateral instrument signatories to choose their position, and India has chosen its position. The fundamental rule is that the principal purpose test in the multilateral instrument has to be read alongside the treaty. It's virtually saying you're holding the treaty on your left side and you're holding the multilateral instrument on the right side. How does that work? But before we look at how does this work, let's look at the web of our Constitution and the Indian Income Tax Act, because for all the judges sitting in this room and for all the practitioners in this room, you are going to be looking at an instrument called a multilateral instrument, and I will just come to the other concept of synthesized versions of the treaty, so on and so forth, but you're going to interpret it within the framework of the law. There are 5 articles in our Constitution that deserve to be looked into for any form of treaty interpretation. First is arising out of what we call it as the Article 51, which is an overarching statement. Article 51 says international treaty should be respected. The Constitution says international treaty has to be respected. We have Article 53, which deals with the executive power, which is vested only with the President. All of you are judicial members here and IRS officer. I don't need to explain that to you. Article 73 is the extent of executive powers, because there is a division between what an executive can do with an act of parliament and what it can't do. Article 246 is the exclusive power of the parliament to make laws, and the power to sign a double tax treaty is arising out of entry 14 of the UN list, which says entering into an implementation of treaty. And Article 253, which found a mention in the Nestle judgment, is the parliament has to make law to implement any treaty with any country. There have been several law commission reports whether you need a domestic law for every treaty, but our section 90 in the Income Tax Act is wholesome, that itself is the empowerment. So I don't want to get into that debate. What I have stated on the right-hand side are some of the guidances that's coming from the Ministry of External Affairs. The latest guidance was updated in 2018, that when you talk about a treaty, a double tax treaty, or a multilateral convention, what are the parliamentary processes that need to be followed to enter into a treaty? It's a 4-stage process. First of all, the President giving an authorization to the person to sign the treaty. Second is the importance of ratification under the signature. You'll see many people talking about the fact that India's bilateral treaty does not need a ratification. That's a wrong statement. We do not need a parliamentary ratification. We don't need a ratification like Americans talk about in the context of taking it through the Senate. But there is a ratification process prescribed in the government rules. And every treaty has to be ratified, because a treaty can be signed only on behalf of the President. The treaty is ratified by obtaining from the President what is called an instrument of ratification, and it comes only under the seal of the President. For a multilateral treaty, the instrument of ratification has to be deposited. Now let's look at how did India fulfill all these obligations when it comes to signing of the multilateral instrument. First, 7th of June, Mr. Jaitley visits Paris to sign the multilateral convention. 12th of June, the Union Cabinet approves the ratification. It's merely approving the ratification post the finance minister signing it. 25th of June, India deposits its final positions on covered tax agreement, notifications, options, because this complex multilateral instrument not just has two minimum standards, but it has non-minimum standards on which India has to express a view. So Foreign Tax and Tax Research Division will express a view on all of this. On 9th of August, India issues a notification under Section 90. Now this is where the fun begins. That notification has been issued for a multilateral convention which is overarching, not qua treaties, but qua a multilateral convention. Then there is a date of entry into force of a multilateral convention, which is 1st of October. 1st of February, India proposes in the finance bill an amendment to Section 90, and the amendment to Section 90 mirrors what is the minimum standard under the principal purpose test, which I read out in the first slide. And on 1st of April, the MLI comes into effect. So this is now the framework. Now, I'm not going to get into the debate that if you supplant the ratio of Nestle judgment, what cocktail it will come out with, but I just thought I will put down all the dates for everyone's benefit. So what is the checklist now for application of MLI provision? Let's assume that the judges sitting in this room are interpreting a treaty read with the multilateral instrument and with all the paraphernalia that I described in terms of process that India follows. How will you interpret it? First of all, let's look at it from what date it will be effective. We have gone past the signatory to the MLI. This is the June 2017 event. We have to go through the treaty partners notifying the covered tax agreement, and I will show you in the latter slides how many of India's treaty partners have notified. Then we will check if there is any reservation that each of the parties to the notification have expressed and how they've expressed, because there is a situation. Then we will look at what is the entry into force of a multilateral instrument, and then we will look at entry into effect. And I'll just explain to you the difference between entry into force and entry into effect. First of all, two fundamental principles of the multilateral instrument. Article 34. Article 34 says that the MLI, which has to be entered into force, it will enter into force from the first date after the expiry of 3 months from the deposit of the instrument of ratification. So let's look at it in the Indian context. Simple example, India signed the multilateral instrument on June 7. India deposited its instrument on 25th June, and hence the multilateral instrument came into effect on October 1. Does this amend the treaty? No. And I'll explain to you why this does not amend the treaty. It merely suggests that the multilateral instrument has come into effect. You have to read Article 35, because Article 35 now gives you entry into force and entry into effect. So Article 35A says that when, and it has different dates for withholding tax, different date for non-withholding tax. For withholding tax, it says on or after the next calendar year from the CTA date. So the entry into force, let's say for Slovenia, when it comes to withholding tax, is October 1, 2019. Sorry, for India, it's October 1, 2019. For Slovenia, it's July 1, 2018, which means that it will be effective in India from April 1, 2020, because it is the next financial year. It cannot apply retrospectively. And for Slovenia, it will be January 1, 2020. So this is just to be able to reconcile now the entry into force dates with our domestic law. Now, let's look at it in the first slide dealt with the withholding tax. Now, this slide is dealing with other taxes. So, the MLI document says that for other taxes, it's on or after 6 months, 6 calendar months from the CTA date. So, what will be the entry into force for Slovenia? It would be July 1, 2018, and for India, it would be October 1, 2019. What would be the entry into effect? Now, entry into effect is logical because India has taxable year begins from April 1, so is April 1, 2020, and Slovenia is April 1, 2020 again. So you see how now just one treaty, you have 4 variables: entry into force, entry into effect, financial year of that country, deposit of MLI, they all fall together. I know this is complex. Trust me, even when I look at this again and again, I have to jog my memory to look about it. But I'm going to end it with some simple slides. If today you look at India's DTAA framework and look at how MLI will apply and to how many treaties it will apply, let's go from the top. India has 97 comprehensive DTAAs. Out of this 97 treaty partners, 93 treaty partners, India has notified them that they are covered tax agreement. But that notification alone by India is not sufficient because to be a covered tax agreement, both the treaty partners have to notify it. So now there are 4 treaty partners of India who have not notified India, and China and Chile are 2 other important partners. I don't know the 2 other countries, but I just thought that, so now you leave out the right-hand side completely because the MLI does not apply to them. But notification or depositing with the OECD by both the partners is not sufficient. Because out of 93 that India notified, 65 treaty partners have in turn notified India, but 28 treaty partners have not notified India, despite being a signatory to the MLI, which means for these 28 partners, the MLI will not apply. We go down further, out of 65 partners, 57 partners have ratified the MLI. 8 treaty partners have not submitted the ratification. Now let me explain to you. The ratification process in these jurisdictions are subjected to constitutional requirement in those countries. So when, despite being a signatory to MLI, when they say they have not notified, it means that they have not gone past their constitutional provisions. Now comes the fun, because this question was posed to me by Mr. Amit Shukla, which is resolving the conundrum of synthesized version of the treaty. I'll explain to you very briefly what is a synthesized version of the treaty. Now, let's look at a document which is a bilateral treaty. Let's look at a document called multilateral instrument. They have to be now read alongside. So the synthesized version of the treaty was a concept envisaged in the multilateral instrument to facilitate reading it as one document. Because, when you read 2 documents, it becomes a little complex. There were other reasons also why the synthesized version was born. Many treaties have been signed in Spanish, French, German, and treaty interpretation has mainly been the forte of English language. Many treaties are very old. Imagine a 1968 India-Greece treaty being read now with the MLI. Those will not make sense. So by issuing a synthesized version of the treaty, you're reading one document, but I will just explain what the MLI says as the legal sanctity of a synthesized version of the treaty. So we have 32 synthesized texts India has published, because this each country decides. Each country decides to facilitate interpretation. Now there are treaties most of the countries that use the Spanish, French, and German are issuing the synthesized version in English, because sometimes the English and the other Latin languages don't necessarily match. We have a situation where one country has issued a synthesized version, other countries have not issued a synthesized version. Any which ways, for the sake of this discussion, let's accept it that we have 57 treaties where both the partners have ratified. Some of them have issued a synthesized version, some of them have not. Purely from a legal interpretation standpoint, all the ratified treaties are on par. So imagine a country that has issued a synthesized version, but another country has not issued. Is there any difference between the two? No. So far as you have treaties which are ratified by both the nation, that has the legal sanctity. Why do I say that? Because the answer to this question is there in the MLI document itself. In fact, in the FAQ, a specific question has been added by way of a disclaimer, which said that the synthesized text has no legal value and the text of the MLI applied alongside, I'm reading it as read alongside, the text of the covered tax agreement would remain the only legal document applicable. This is the OECD version. So synthesized version, in my view, have no value, neither do they create any rights or obligations if you look at the commentary as well. Sir, how am I doing on time? 5 minutes? Okay, I'll finish in 5 minutes. Beneficial ownership. Beneficial ownership applies only to certain articles of income, passive income like dividends, royalties, fees for technical services, and interest as well. We all know that. We all know the importance of that as well. There is a definition which we all look into it. There is also a purpose, and the purpose is very important because very often it is confused that a beneficial ownership concept is an anti-abuse concept. Not necessarily. If you look at the various versions of the OECD commentary, how it is, including the UN commentary and the text, you will realize that beneficial ownership is also to make sure that income is allocated correctly. Of course, a related objective is that taxpayers should not make abuse or not fulfill beneficial ownership test only with the sole purpose to claim treaty benefit. Obviously, the importance of beneficial ownership has gone up after the principal purpose test has been born. And the question in everyone's mind is, how do you now look at satisfaction of beneficial ownership and the principal purpose test? Let me go back to 1977. There are 3 important versions of Model Convention. Equally, there are 3 important versions of commentaries that are supporting the Model Convention. The 1977, in the context of dividends, said, but if the recipient is the beneficial owner of the dividend. So the focus is on the person who is receiving the dividend. 1995, nothing fundamentally changed, but the focus shifted from but if the recipient is the beneficial owner of the recipient to but if the beneficial ownership. So the word recipient was deleted in the 1995 convention. However, the 2014 convention looked fundamentally different. This is where the shift happened on the concept of beneficial ownership from allocation of income to an abuse situation. It says, however, dividends paid. So the focus from dividends was dividends paid, and in the latter paragraph, but if the beneficial ownership of the dividend. Now, this was identical, the latter paragraph of 2014 version was identical to the 1995 version, so the only change that took place was the shift from dividend to dividend paid. Now, these are all my interpretation slides, but this is how I will demonstrate some of the foreign courts are interpreting. Now, the evolution of the concept of beneficial ownership had many, many facets to it. It depended on what era it was looked at it. So in the 70s, as I had mentioned, it was for income allocation purposes, but there were certain instances of tax abuses that were occurring. where the recipient of income, dividend is just one example, it could be interest, it could be royalties and fees for technical services, were being earned by intermediaries, were being earned by nominees, were being earned by agents. So that's the first time it dawned upon the likes of OECD to bring the concept of beneficial ownership. In 1986, when the conduit company concept was born in Europe, at that point in time they said, well, these conduit companies are nothing but they are acting on behalf of as an agent. So that's the other development. 2003 commentary clarified that first time that the beneficial ownership should not be used in a narrow technical sense. You could have situations beyond conduit, beyond agent. 2014 version was again a watershed version that articulated, and in 2017, which is a standard that applies today, beneficial ownership has many, many facets. Now you need to read beneficial ownership with Article 29, which is limitation of benefits. You need to now read beneficial ownership with friction that it could potentially occur with principal purpose test. Though there is no fundamental change in the model convention, but there is sea change in the commentary that supports it. Again, I'm not going to go through this slide in the interest of time, and it is too verbose, but I just wanted to demonstrate that if you read beneficial ownership from a commentary standpoint, you will be able to figure out how fundamentally different it is. Now, there are many facets to beneficial ownership test, but there are many aspects, and each country will interpret beneficial ownership in the context of their domestic law. And their domestic law will include everything, public policy. India's stated public policy is against tax evasion. So India will have its own version of interpretation of beneficial ownership. But the fundamental rules for interpretation will not change. And those would be, is it a legal interpretation? Is it a substance over form interpretation, or is it both? If I look at Indian cases, and I just wanted to talk very briefly about the Tiger Global case, India looks at it from both standpoints, legal interpretation and substance over form. I'm not going to get into our rich jurisprudence, whether it's McDowell or Vodafone or others. Maybe there is a shift that's happening from legal interpretation into a substance over form interpretation. But I have no doubt in my mind that the world is moving more to a substance over form interpretation rather than legal interpretation. 4 landmark cases in the last 10 years. They are going to be the guiding post. 2 of them by Court of Appeals in the UK, which is the final court, and another important case in Korea. All of them in favor of the taxpayers, but the reasons the court has given, arrived at, are very different in all the 4 cases. In the interest of time, I'm not going to go through it. I just wanted to make one mention about the Tiger Global case. Not about the case, because the matter is, the judgment is about to come from the Supreme Court, but more talk about the history. What did the Delhi High Court say? What did the Delhi High Court do? There's a whole lot of pages after pages written in Tiger Global talking about beneficial ownership. And it concludes in para 242, 243, 244. But Tiger Global was dealing with an income that was characterized as capital gains. So the question was, beneficial ownership does not apply to capital gains. What was the need for the court to get into that commentary on beneficial ownership? I could not follow that. But when I was watching the proceedings in the Supreme Court, I could follow that. Because Mr. Salve did not argue on beneficial ownership, because beneficial ownership doesn't find a mention in the capital gains article. Neither did Justice Pardiwala question on beneficial ownership. But this commentary in Tiger Global on beneficial ownership is an excellent commentary, because it's one of those cases where a High Court judge has brought together every principle on beneficial ownership. So, though not relevant for the purposes of the decision of Tiger Global, but the commentary makes an excellent read in my view. Last point, inextricable link between principal purpose test and beneficial ownership. I mentioned about the relevance of Article 29.9. Article 29.9 finds mention in the OECD 2017 Model Convention. It has three distinct elements: a subjective element, an escape clause, and what I label it as a vague clause. Dr. Akim Prost from OECD makes me feel that that's the sarcastic part of my personality, which is a vague clause. But I've actually supported it, why I feel that's a vague clause. The subjective clause is very clear, one of the principal purposes, which it finds mentioned in our GAR law as well. The escape clause is very important, and the escape clause is very tricky. It's tricky for the taxpayer, it's tricky for the administration, but I promise you, it will be the most tricky for any judge who's writing a judgment on the escape clause. Assuming a taxpayer satisfies the subjective test, and a GAR is being invoked, or a treaty benefit is denied because of principal purpose test, the escape clause says, unless it is established that granting that benefit in these circumstances, what we call its facts and circumstances of the case under our Indian Convention, would be in accordance with the object and purpose of the relevant provisions of this convention. This is an area where only facts can support whether a taxpayer has an escape clause or the invocation of the GAR or the PPT law by the administration does not satisfy the escape clause. And then is my favorite, the vague clause. Reasonable to conclude. Who is supposed to be concluding? What is reasonable? Taxpayer or the tax administration? Go to the left-hand side of the Article 29.9. Notwithstanding the other provisions of this convention, a benefit shall not be granted if it is reasonable to conclude. This is, in my view, the most vague clause I have come across in any international convention. I keep on arguing about it. OECD does not agree with me, but this is going to be fun when it actually comes into play. My parting thoughts. Beneficial ownership, in my view, deals with specified and restricted situations of conduit. It doesn't deal with all situations. We don't have cases in India where a treaty claim has been denied because somebody is not satisfying the beneficial ownership test, but somebody is the beneficiary of that income. What if that somebody happens to be coming from a country with which India has a tax treaty? Are you going to give the treaty benefit to that person? In my view, the answer should be yes. We have not tested that in India. Application of beneficial ownership and principal purpose tests are independent. I entirely agree with the view of the Indian administration. They apply differently. If you read all these documents, if you read the framework of the Indian law, they apply differently. Beneficial ownership is only for passive income and focuses on legal and contractual obligation to pass an income, regardless of the purpose or intent. You cannot look at the purpose of the intent. You can merely deny a treaty claim because so-and-so happens to be not a beneficial ownership test. Finally, a principal purpose test, in my view, is much more wider. It encompasses benefits, double taxation, tax abuse, foreign tax credits, everything. So don't confuse principal purpose test with beneficial ownership. Beneficial ownership, at best, is a subset of the principal ownership. Also, we need a lot of guidance to deal with this. If we don't have guidance, this room will not be filled by 300 people. 10 years from now, there'll be 3,000 people. Thank you very much.
Thank you so much, Ms. Mukesh. Substance of our form suggests that everybody is hungry. 57 dishes waits outside. You are the real beneficial owner of that lunch. In good faith, I request Mr. Wadhwa to tender vote of thanks because he has already written a paper in his iPad. Please, Mr. Wadhwa.
Sir, when it comes to my turn, you are reminding everybody of lunch. Sorry, they'll have to wait. I mean, so please pardon me for that, but I need to go at my own pace. My Honorable President, my 24/7 President of the ITAT, Justice Badang. Justice Badang, I would not leave it at that. He is not only 24/7, but he is heart, body, and soul into the tribunal, and I'll have a personal experience to cite. You know, I send him a message wondering that he'll be busy, so I shouldn't call him. And take it from me, before the day ends, there is a response. Such is his level of commitment. Whenever he's in Delhi, he gives us an audience, extremely patient, and has always a solution, pacifies us, and is always thinking. Sir, thank you very much. Now, the only thing, sir, the only little disservice that you did was of telling me only yesterday evening that I'm on this dais before Bhutani, and somebody who's talking an international tax, and I barely know the meaning of international from the international tax perspective, but doesn't matter, sir. My Honorable Vice President of Delhi, Honorable Vice Presidents of all the zones, members of the tribunal, my very large contingent from Delhi, sir, all those people that you see behind are from Delhi, sir, putting a lot of weight and pressure here. And my colleagues from all across the country, thank you for coming. And it's a fantastic, fantastic session. I mean, I haven't seen a better, well-attended session and in a more congenial atmosphere. PPT, I'll come to that. Principal purpose test. I've understood, sir, today. About Mr. Bhutani. A lot has been said about his academic and professional accomplishments. I would only say extremely genial, affable, accessible, and he's like a rock of Gibraltar for the ITAT Bar Association. Whenever we need him, he's there, and a smiling face. His smile hasn't changed all through his age, and that's the reason for the youthful looks. Very soon we are going to have a fashion show among the members of the tribunal and the members of the Bar Association, sir. Sir, you qualify because of your youthful looks. But sir, there is one Mr. George and there's a gentleman there. Sir, very handsome people, so we'll have a different one, sir. And you also would be there, sir. Sir, Mr. Prashant Maharishi, the ITAT skipped a heartbeat. When I say the ITAT means everybody skipped a heartbeat when we learned that he was unwell. So I was wanting to meet him, test whether he's okay. And when I met him and he cracked a joke on me, I was relieved. I said, now he's fine, absolutely fine. His faculties are all first class. Extremely, I mean, I'll say an epitome of humility. And that's what a model member or a judge or a person donning such a position should be. Sir, I am a butt of ridicule. You know, some people say, they ask me, how many years have you been the president? And today somebody said, 75 is the year of retirement for leaders, so you have another 13 years to go. I keep listening, sir. I have, like all other politicians, I'm a chekna kada. Bolte raho, theek hai. So as long as, unless you throw me out, I'll continue. So, but sir, on a serious note, in my journey, what I have seen is, this institution, sir, is like river Ganges. Flows, purifies, a perpetual river of great sanctity and reverence. And that is primarily because of the tenure the members have had. They joined at 35 plus, retire at 62, domain experience, continuity. Sir, no offense, no objection to the Honorable Secretary. Today took note of this observation by Mr. Nanda that 4-year rule is detrimental, is antithetical to the tribunal itself. So we feel very strongly about it, very strongly about it. And today I can tell you, I was counting, we are 200 plus here, sir. Democracy is by majority. But when there is not even a single dissent, then that should rule. There is not a single voice here who would say that 4-year rule is antithetical to the concept of the tribunal. Not a single. So if that's the unanimous verdict, why should we not go back to that old system where you join and you retire? And you have the domain experience, you have the loyalty to the institution, you breathe for the institution, and that's the way it ought to be. So we are going to, as all the bar nominees, we are going to ghirao the minister today, because good that he's coming today and going to stay till tomorrow. So we'll ghirao him and we will put forth our point in the most forceful manner. Sir, on Nestle, I have to make some sense. पढ़ा लिखी वाली थोड़ी सी बात करनी है. सब उसमें ये है. See, the point that I'm really concerned about. Sir, just give me a second, sir. Now, 5% is the tax on dividend, which is because of the MFN status. I mean, my friend has just communicated. Today, the situation is that we want technology into India and desperately need technology. Because every second of our living moment, we are paying for technology to the rest of the world. Netflix, Apple, and we get nothing in return. We want technology. And how do you get technology? By people investing into India, by companies investing into India. Now, is 5% dividend rate a controversy on such a thing? It's a small fiscal concession compared to the long-term benefits of demonstrating respect for international treaty. Oh, fine. Supreme Court has interpreted to say that it would not apply the MFN status because you should have been an OECD member, Slovenia, etc., when you gave them the concessional rate. Well, what is the CBDT doing? And in the same vein, what is the policymakers at the top doing? You bring out such a litigious state. What impression are you giving to the others? They are deducting tax at source at 5%. You continue your 10 or 15, 20% and do not bring a quietus to this. This is where the CBDT should come in. Now, what else will happen with this? Sir, there is this law affirmed by Kokia Behan by the Supreme Court that there has to be a finality to proceedings. If a Supreme Court, let us say, has decided 20 years ago that this income is taxable, and after 20 years they say it is not taxable, you can't pick up those cases and reopen them. The ones which have been decided and which have attained finality. My friend says here that the High Court decided on this issue 15 years ago, and that's the settled law of the FMF status. Now, is it not equivalent to a Supreme Court giving a decision that this is the status because you acted on it? Now when the Supreme Court changes, you go back. And when you go back, you levy interest. And you subject all those people to harassment. My point is, litigation apart, our benefit apart, work for the Honorable Tribunal members apart, that's not the answer. We continue to be in the list of 200 countries, 140 in terms of poverty. We don't deserve this kind of litigation and this kind of impression that goes around that point. That's the only point that I was wanting to make. On the beneficial ownership, sir, look at the Companies Act. When the interpretation of beneficial ownership comes up, Companies Act says disclosure of beneficial interest of an individual. They look at beneficial ownership from an individual exercising control as a beneficial owner. If this is looked at by the courts, another interpretation will be given. So I don't think, I think some holistic view needs to be taken and the global practices needs to be. Thank you so much for the time afforded to me, sir. I had the opportunity. Bolna to sir tha hi mere ko. Thank you so much, sir. Grateful to you, sir. Very, very grateful. Thank you.
Now the lunch is waiting for all of us. Session is concluded.